On this edition of Law Weekly, we assess how well President Tinubu's administration has fared 1 year in office. We also talk judicial reforms. My guest is Senior Advocate of Nigeria, Mr. Tayo Oyetibo. Also showing on the program, the Attorney General of the Federation and Minister of Justice, Senior Advocate of Nigeria, Lateef Fagbemi, has been speaking about the achievements of the Ministry of Justice as part of activities to mark President Bola Tinubu's 1 year in office. He says the federal government secured 250 convictions from prosecution of terrorism in the country in the year under review. Plus our recap of the top legal stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. My guest, Tayo Oyetibo, is a very senior legal practitioner who knows too well some of the challenges facing the legal profession. He's been a consistent voice for reforms in the legal profession and a strong advocate for the rule of law and for doing things properly. I had a chat with him again about what reforms are urgent and how to achieve same.
Now, when you talk of access to justice, you can't divorce access from exit, because if you enter the court and you remain in court for a number of years, you have not got speedy justice. So for you to talk of access to justice, you must think deeply about exit. What problems do we have today? When the case starts at the High Court level, it is not over until it runs its full course, probably to the highest level of the court, which is the Supreme Court. Because if either party loses at the first level, the loser may want to go to the next level, from the next level to the highest court. And I tell you this, and I've been saying this for quite some time, our Supreme Court has so many cases that ought not to be before them. And I give you examples. Why should Supreme Court be saddled with chieftaincy cases? Why would our Supreme Court be saddled with customary marriages, assault, stealing, issues that can be resolved at the state level? Why go to a Supreme Court? So if you have a system whereby litigants can know their fate within the period of 3, maximum 5 years, running from the trial court up to the final court, I think that is what we should be looking at in terms of access to justice and exit. Because if you access the system and you are retained there and you are not able to come out of the system, to me, you have not got anything. Because even monetary cases, if you get judgment for 10 million naira at the High Court, by the time you get to Supreme Court over 20 years, the 10 million naira is nothing. A judgment that was obtained in the 80s when a dollar was a 50 something kobo under the Nigerian foreign exchange system. Today, if you have a 1 billion judgment in 1986, and there are 1986 cases still pending in the Supreme Court. Yes. There are 1986 cases still pending in the Supreme Court. 86 cases that started at the High Court. How much is that today? That's down to nothing. So we must devise a means of amending our constitution, which permits most of these cases to get to the Supreme Court, that they shouldn't go there, so that you can exit as quickly as possible, and then you know your fate, and you can do whatever you get from the court in terms of favorable judgment. You can find a way of dealing with the fruits of your judgment.
So what kind of cases should go to the Supreme Court?
Usually constitutional cases, interstate cases, cases between federal and state governments, cases that involved like currency, taxation, cases that involve the customs, matters that are on the exclusive legislative list that you can see, they are probably matters that involved interstate conflict. So those are matters that should go to the Supreme Court. The system has to invest in its judiciary. You invest in the infrastructure, then you invest in the personnel, the appointment process. Because if you invest in infrastructure and you don't invest in the personnel, you have not got it. You must ensure that the appointment system to the High Court bench, to the Court of Appeal, and to the Supreme Court is well managed and scrutinized, so that you get the right personnel, the right hands to be on the bench. You must improve on the remuneration of judges to attract good hands, so that nobody has to look over his shoulders to be able to fend for himself while he's writing a judgment. You must make them contented with what they have.
Since you've talked about appointments and remuneration, I want us to look at the issue of merits in the appointments of judges. We complain that judges are poorly paid, but the counter-argument is that they recommend their children, siblings, and we've even heard of mistresses into office.
You see, for some years, the bar had advocated that members of the bar should be appointed directly to the Supreme Court. It has not happened. When you are talking of quality, in the past, there are some chief judges that were appointed directly to the Supreme Court. Oputa, for example, Justice Oputa, went directly from the High Court to the Supreme Court. Justice Kriggs, Justice Nwokedi, I think Justice Kawu, they went directly from High Court as Chief Judge to the Supreme Court. If you spot good materials at the High Court level, there's nothing stopping you from sending them to the Supreme Court. Yes, if you spot good materials at the bar, there's nothing wrong in asking them to come to the Supreme Court. The Supreme Court is the final court. It has a complement of 21 justices. So the 21 justices should reflect the variety of resources that we have at the bar. That's the point I'm making. You should take from academics, you take from the bar, you take chief judges, you take from Court of Appeal. So when you get to Supreme Court, you have a blend of different background of judges.
What about the issue of ethics in the legal profession? How do you suggest that we handle that? Because we've also heard that it's the senior lawyers who are used to bribe the judges.
Let me take, it takes two to tango. Okay? No lawyer can corrupt an incorruptible judge. That's the truth. The two must be corrupt. If a lawyer brings money to you and you are not a corrupt judge, you should send him away. That is the truth. And if a lawyer knows that a judge is incorruptible, he will not take money to him. So, the lawyer is corrupt, the judge is corrupt in the business of corruption. The lawyer who takes money to the judge is condemnable. The judge that accepts the money is condemnable. But the two must agree. That's the point. There are judges that have rejected. I mean, if you know your onions and you are a judge and people know you, nobody will bring money to you. Nobody will attempt it. When Justice Oputa was on the bench, would any lawyer walk into his chambers and say, I want to give him money? Who are you to do that? Will you? No. So, the quality of the judge, the background of the judge also matters. It does. And lawyers know incorruptible judges. We know.
And they know the corrupt ones.
And you also know the corrupt lawyers. Of course, yes.
Finally, how well would you say the President Tinubu administration has fared 1 year in office? And how well would you say that they have enabled the judiciary do its work effectively?
Honestly, Shola, let me say this. To have an unbiased assessment of the Tinubu's administration, you must go back to look at the 8-year period that preceded his administration. To me, that period, the hand of the clock was turned back by more than 10 years. So, if you want to assess the person who takes over from an anti-clockwise system, what he is doing, in my own opinion, is still planting. And as a farmer, when you plant, you water before the fruits will come. I do not see how Nigeria can get anything meaningful from this government within the period of 1 year, having regard to the 8-year period that preceded the administration. Nigeria was turned backwards more than 10 years in the 8-year period preceding the administration. So, quite frankly, I don't think we should be hopeful that within the 1 year we'll begin to reap fruits. I mean, I'm being frank, I'm being sincere with myself. If you think that it will just drop on our laps like that, it doesn't happen that way. So, if he's planting, let him plant well and plant fast and then water quickly so that the fruit can come. But if we are expecting fruits within the next 18 months of his administration, the first 18 months of his administration, we'll be deceiving ourselves. I expect the present administration to improve on the conditions of service of judges. That's my own position. Because if you want investments in your country, you must ensure that your judicial system is transparent. You must ensure that you have good quality of personnel on your bench. That's when you can attract investment. People run away from your system when they feel that they are not likely to get speedy justice, they are not likely to get transparent justice. So they take their commercial disputes away from your jurisdiction. We have to think deep on that. And the best way is to put the right people on the bench and also support the judiciary with the right infrastructure.
Welcome back. The Attorney General of the Federation and Minister of Justice, Senior Advocate of Nigeria, Lateef Fagbemi, has been speaking about the achievements of the Ministry of Justice as part of activities to mark President Tinubu's 1 year in office. He says the federal government secured 250 convictions from prosecution of terrorism in the country. He also disclosed that his ministry is in conjunction with relevant security and law enforcement agencies who have developed a framework for joint investigation and collaboration, just as the ministry has also facilitated international cooperation on terrorism financing and other transnational crimes.
In conjunction with relevant security and law enforcement agencies, the ministry has developed a framework for joint investigation and collaboration geared towards the engagement of prosecution-guided investigations in various criminal cases to address the challenges to successful prosecution. In furtherance of the ministry's mandate of ensuring national security and safety through prosecutions, the ministry secured 160 convictions of criminal offenses, 87 convictions for terrorism cases, 3 novel convictions for extreme terrorism actors involved in the radicalization of children and violence against children, women. This is also enhanced. There is also enhanced interagency synergy for prosecution of maritime cases, electricity offenses, collaboration with public and private sector stakeholders on cybersecurity protection and cybercrime prosecution. I am pleased to report that following the ministry's intervention for upgrade of facilities designated for trial of terrorism cases, the ministry has resumed trial of terrorism cases in conjunction with the Legal Aid Council, National Human Rights Commission, and other critical stakeholders. The percentage of terrorism cases initiated and corruption cases concluded within the reporting period has been significant. Facilitating international cooperation on terrorism financing and other transnational crime. I wish to report that the mandate extends to matters relating to finance, cybercrime, anti-corruption, laundering, terrorism and genocide and complex cases. The following are our achievements in these areas. A. Conviction of 13 terrorism financing cases. We have also successfully concluded 150 mutual legal assistance requests and 12 extradition requests from law enforcement agencies and foreign countries. The ministry places serious priority on enhancing the prosecution and litigation capacity of its staff. To this end, it organized capacity building programs to improve knowledge on various aspects of the law, including darknet and cryptocurrencies applied to terrorism financing, investigation and prosecution of financial and wildlife crimes in Nigeria, the coordination of the effective implementation of the National Anti-Corruption Laundering Combating Proliferation Financing Strategy 2023-2027 is also a top priority for the ministry. On anti-corruption, the stance of the federal government is adequately captured in the presidential focus, quote, fair and safer playing fields, unquote. A major positive development in the anti-corruption strategy or agenda is adoption of the National Anti-Corruption Strategy. The National Anti-Corruption Strategy was first adopted by the Federal Executive Council in 2017, and the policy spanned 2017-2021. The implementation has now been extended to 2026.
We move on now to the fast approaching 2024 Law Week of the Nigerian Bar Association's Lagos branch. The leadership of the branch and the Conference Planning Committee has held a press conference to shed light on some of the planned activities for the Law Week. The chairman of the branch and the chair Conference Planning Committee says the Law Week will, among other things, discuss the issues of ethics and discipline in the profession, how Nigerian lawyers can collaborate with their foreign counterparts, as well as the pros and cons of cross-border practice.
We've come up with a theme which I think is germane to where we are. We all know that we're in an era where, with the rapid globalization and technological advancement, there's a need for us to think inward and see how we can, as lawyers, meet up with the challenges and the shift in the practice of law. And that's why we came up with this theme about charting new legal frontiers, the practice of law in Nigeria, cross-border alliances, and partnerships. As we all know, a lot of law firms, both in Nigeria and outside, are all having various forms of alliances that are bringing in professionals from across the world to come into the country. We don't want to be left out, and that's why we've decided to actually engage and discuss in how we can, with technological advancement, AI, blockchain, the world is changing. Opinions that we used to write for that will take me three weeks to research on can be written within 3 hours. So where are we? And that's what we're going to be discussing at the Law Week.
Judges still writing long, and I picked up my phone today and I saw a judge sending a notification that we'll be sitting on the day of the matter. You know, so those kind of things are the things that do not give any inspiration to the justice delivery system. You need a system that is certain. You need to know that if I go to court in January, by December I would have gone out. You need to know that you can use technology. A lot of our colleagues are still struggling with WhatsApp, emails. So we're not faring well at all. And so the idea behind the theme of this Law Week is to tell our colleagues, this is how it is done abroad. Can you, as a practitioner in Nigeria, can you compete with the colleagues who are in UK who are practicing? If you allow the Nigerian economy to be open, Nigerian legal space to be open, can we compete favorably? Can we compete favorably with our colleagues from abroad? The answer is certainly no. And so the idea behind this kind of discussions is to begin to put us in the right direction on the things that we must do to be able to fare in a competitive legal market. And so until we get our acts right, I'm sorry, we're not doing well at all.
And just before we go, a quick recap of some of the top legal stories in the news.
It's no longer news that a former governor of the Central Bank of Nigeria, Sanusi Lamido Sanusi, has been reinstalled as the Emir of Kano. But before that ceremony took place, a federal high court sitting in Kano had issued an ex parte order preventing the state governor, Governor Abba Yusuf, from reinstating him as Emir. The court also barred the implementation of a new bill that abolishes the 4 emirates of Bichi, Gaya, Karaye, and Rano. The order given by Justice Mohammed Lima directs all involved parties to maintain the status quo pending the determination of a suit filed by Sarkin Dawaki Barba and Aminu Baba Dan Agunde. The suit challenges the recent actions taken by the Kano state government. The case has been adjourned to June 3, 2024 for the hearing of the fundamental rights application. The court has directed that the plaintiff and applicant may serve the originating motion and other court processes on the Inspector General of Police in Abuja outside the jurisdiction of the court. In Lagos, another former CBN governor was in the news. At the Federal High Court sitting in Lagos, Justice Yelim Bugoro ordered an interim forfeiture of the sums of $4.7 million, 830 million naira, and several property linked to Mr. Godwin Emefiele. Justice Bugoro made the order following an ex parte application by counsel to the Economic and Financial Crimes Commission (EFCC), Bilikisu Buhari. The court ordered the EFCC to publish this order in any daily newspaper circulating all over the Federation for anybody interested to show cause why the final order of forfeiture should not be made. It subsequently adjourned to July the 2nd to hear the application for the final forfeiture. The properties forfeited to the federal government includes 94 units of 11-floor building under construction at Ikoyi, Lagos, the AM Plaza, 11-floor office space, as well as other property in the Lekki area of Lagos. In Abuja, a former Minister of Aviation, Mr. Adi Sirika, and his brother Ahmad Sirika have been arraigned before an FCT High Court over alleged corruption charges. The Economic and Financial Crimes Commission had filed a 10-count charge against the Sirikas for an alleged contract fraud valued at 5.4 billion naira, to which they pleaded not guilty. Following their plea, lawyers to the defendants applied for their client to be granted bail. The presiding judge, Justice Suleiman Belgore, granted them bail in the sum of 100 million naira and 2 sureties in like sum. The judge further ordered the defendants to provide sureties with landed property and certificate of occupancy signed by the FCT minister. The defendants are also prevented from traveling out of the country without the express permission of the court. Staying in Abuja, the trial of the detained Binance executive Tigran Gambarian at the Federal High Court took a dramatic turn following the defendant's collapse in court. At the resumed trial, the defendant failed to enter the dock when he was called upon by the court registrar for continuation of trial, as he remained seated at the back seat. Following the failure of the defendant to enter the dock, the trial judge, Justice Emeka Nwite, asked after him. One of the lawyers in the defense team who sat beside Gambarian assisted him by the side while holding his hand towards the dock, but as they walked slowly to the dock, Gambarian slumped and the lawyer helped him to sit in the front row seat. The lead defense lawyer, Senior Advocate of Nigeria, Mr. Mark Modi, however, told the court that his client had been indisposed and a written application letter had been filed to notify the court of this. Gambarian, Anjawala and Binance Holdings Limited are facing money laundering and terrorism financing charges brought against them by the Economic and Financial Crimes Commission. Lawyers to the detained leader of the indigenous people of Biafra, Nnamdi Kanu, has filed a preliminary objection at the Federal High Court Abuja, asking Justice Binta Nyako, the trial judge, to decline jurisdiction to proceed with a trial against him. Part of the issues for determination is whether the court has the jurisdiction to try him for any or all the offenses charged against him and to quash the counts on the ground that it is unconstitutional. They pointed out that there are 2 international tribunal decisions against the arrest, detention, prosecution, and trial of Mr. Kanu, which by virtue of the Nigerian constitution is binding on the court. They also state that the law under which Mr. Kanu is being tried has been repealed, is not supported by proof of evidence, and is an abuse of court process. And we round off with a report that Justice Emeka Nwite of the Federal High Court Abuja has granted the erstwhile commander of the Force Intelligence Response Team, DCP Abba Kyari, temporarily bail for 2 weeks on compassionate ground to go bury his mother. He was granted bail to the tune of 50 million naira and a surety in like sum. Justice Nwite also held that the surety which shall be his counsel in the matter should deposit a copy of his call to bar certificate to the Deputy Registrar of the court. Mr. Kyari is to deposit his international passport with the court and should always report to any NDLEA information nearest to him within the period the bail was granted for. The trial judge gave the order pending the ruling of Kyari's bail application slated for May 31, 2024.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Shayeli. Thank you for watching and see you next week.